Hello, my name is Olurotimi Osha, and today I want to talk about abuses in Montgomery County, Maryland's criminal justice system. On May 16, 2023, um, I was raided via a swatting, right? A swatting is when a false police report is made to emergency services of a crisis, right, of an ongoing crisis, imminent or ongoing crisis in the victim's residence. And the purpose is to generate a large police presence, armed, police response. That's SWAT, right, like a SWAT team. And that's normally uh, that's the objective. It's a criminal harassment tactic. It's actually illegal. Those who do such things are, they are criminally prosecuted. But in this case, apparently the swatting was instigated by Montgomery County law enforcement. Part of them, they were part of those who instigated this swatting harassment. One of the people was a Sergeant Charles Drengwitz, who's retired now, a Heng Chin Chen, amongst others, and of course Jide Wariri, a Howard University professor. Now, today, that's not what I want to talk about because I've done videos discussing what happened. So, false charges were filed against me, malicious prosecution, right? So, I'm entitled to my day in court according to the Constitution, right? I'm an American citizen, I have constitutional rights. So if false charges are filed against someone, you have the opportunity to have the case dismissed if a judge reviews, right, an evidentiary hearing or through motions. The judge reviews and sees, well, that your attorney can make a case and show to a judge that this is a malicious prosecution. The charges shouldn't have been filed. In any event, the other option is, you get to show, show that you're innocent at trial. Of course, the burden of proof is on the state because it's the state that has to prove to a jury, right, beyond a reasonable doubt, that you are guilty of the charges um, that they've leveled against you. And of course, they need evidence. Part of the evidence that the state can use is testimony, right? So in this case, the police wrote false um, charges, false statements. They made false charge statements in the able to be able to get the charges against me. So the police wrote a charge statement, went to a commissioner. The commissioner, you know, uh, docket, put it in the system, ordered my wrongful arrest. This was after I'd actually been raided. I was in the hospital. I was actually raided. I'd been assaulted when the police went to the. I was already in custody when the police went to the commissioner, right? So I was arrested subsequently after I was released from the hospital, right? So the police went and made false charges, made a false statement, false accusations, fabricated evidence to be able to get a commissioner. Now, the original charges that were filed against me, there were five first-degree felony assault charges, right? All of those were dismissed when a private attorney reviewed the evidence and saw that they were fabrications. It was a lie. So all of them were dismissed. So a state attorney named Thea Zumwalt, in order to coerce me to accept the plea bargain that they had concocted, right, in order to prevent me from bringing a wrongful prosecution, a 42 USC Section 1983 case against them, and 18 USC Section 242 um, 18 USC Section 242 deprivation of rights case, charge against them. The assistant state attorney at the time, Thea Zumwalt, would file another false charge, a second degree assault charge that never occurred, right? So saying, well, she said it in court that she knew I was a victim, but she filed the false charge as a mechanism to force me to go and do a mental health evaluation and take treatment. And they immediately offered me a plea bargain offer that, well, if I go and do this evaluation, and if I plead guilty to something I didn't do, they give me a suspension of what do they call? Is it probation before judgment, right? Suspended judgment, right? And so long as I don't get into trouble and that they get it off my record. But the thing is, that's a coercive tool, and that's one of the ways the state of Maryland continues to keep black men under the law, right, under the criminal justice system, and continues to instigate them to get back into jail, right? So when they give you those probation, right, those PBJs, many times they end up violating that probation in one form or the other, right? And in my own case, it's particularly it's a perversion of justice, considering that I am completely an innocent man. I was in my home. There was no probable cause. There was no crisis. I was not committing any crime. I was alone in my home, and uh, somebody went to make a false statement, right? False accusation against me that I was completely unaware of. And then police came to raid me. That was a swatting. They came to raid me, and then the police lied. The police assaulted me, shot me. See, these are permanent scarring that they've left me. Shot me in the head, tased me multiple times. The police even stole my property, right? They injured me. They sexually violated me by removing me naked from my home and recording me naked, completely naked, dumping me in a hospital. I suppose they wanted to use that as blackmail. That, well, because for some people, many of these cops are dumb, right? And they're barbaric, right? I guess you can imagine what those many of these soldiers, those that were convicted, did in Iraq, how they would humiliate. They do these humiliation rituals, maybe thinking that these their victims would commit suicide or do something. They have this. They want to humiliate you in such a and to cause you some kind of psychological anguish. So this is what they did to me. I was somebody in my home. I'm not going to get into why they did all of those things today. Today, I just want to talk about how the Montgomery County Public Defender's Office is co-opted by the State Attorney's Office. That's John McCarthy's State Attorney's Office, which is corrupt and racist, and they sabotage the cases of black defendants because this is what I've experienced. So I've done other videos. I'm not going to go into detail. But the thing is, so I've maintained my right that, well, I want to be able to clear my name, get my vindication, get justice in a court, right? That's my Sixth Amendment rights. You get a right to a speedy trial. That's been violated. So under the law, once they file criminal information against you, they have 180 days to bring it to trial, unless there's cause, right? There's cause why that didn't happen, and but your attorney should file a violation of speedy trial, and the judge can review and see, well, was there cause for violating that 60-day trial, that requirement for a speedy trial, or was it done on bad faith? Was it bad cause? Was it something fraudulent, like fraud upon the court, or abusive process? And in my case, there's been abusive process, procedural unfairness, especially perpetrated by the Judge James Bonifant, who just ostensibly apparently retired on March 13, 2026. I'd filed a judicial complaint against him, and he was under investigation, several, and they kept saying it was pending, right? So one of the things that they can do, if they find that, okay, he did commit judicial misconduct, is to force him to retire or whatever. But of course, they try and cover it up, right? Because the state of Maryland, they don't want to make it look, they don't want to make it obvious, because it's they want to protect the integrity of the system, right? They don't want to make it clear or apparent that there's been a tampering, with the proper functioning of the courts, and that's what Judge Bonifant has done. So, in any event, I've maintained and wanted to go to trial. So, I've had several public defenders. I had a private attorney initially, but the private attorney that I was that was representing me was hired by the man um, who went to fabricate an emergency evaluation petition, Jide Wariri, and he's the one who apparently instigated the cops to come to my home, wrote perjured things, and he's supposed to be the chief witness of the state, which is bizarre. So I went to the NAACP to help me as well with the investigations. So their legal counsel told me, fire this guy. His name was Steve Mercer, the private attorney, that he's not really representing me. He's just a normal attorney. He's really protecting Jide Wariri, the man who fabricated evidence, went to write a perjury and emergency evaluation petition that ostensibly brought the police to my home. You know, this is what the narrative has been, that, well, the reason that 40 cops showed up in my home and the SWAT team was because Jide Wariri said I threatened to shoot him and all these things. And I said my home's a military base. At the hospital, they told me that he actually said that, and his attorney said he said I had bombs. So you see, once you start a false narrative, right, it gets, there's this it's lost in translation, as it's being transmitted. They start to remix and embellish things, right? So it blows out of proportion. So one doesn't even know what's what. But I saw along the way, there's been all these defamatory remarks of what I said I was going to do or what I was threatening to do on this May 16 that brought the police to my home, May 16, 2023. All fabrications. I've talked about how they used two ex parte orders. So in any event, I fired Jide Wariri and I started using the Office of the Public Defender. So I've had different public defenders. They've been sabotaging the case as well. I'll do subsequent videos and talk about how each one has sabotaged the case, used deception, committed attorney misconduct. So it's a common thing. And I'm seeing from my experience, right? I have a law degree. I've talked about how I hold a Juris Doctor from George Washington University Law School. I don't practice. I'm not licensed to practice. But and does not constitute legal advice. I'm just talking with regard to my experience and from the interviews, investigations I did when I was wrongfully detained. I found out that this is a typical thing that Black Americans face in Montgomery County very routinely. So eventually, the trial was set for November 27, 2023, the first trial. The judge had placed me under house arrest. He didn't want me to go to work. I had a job. I knew a new job offer, six-figure, at the Pentagon, but the judge did not want me to go to work. So my employer said, well, okay, go and resolve this, go and take care of this, right? And then we'll do something, but take care of this first, right? Because you have these false charges. It looks like, and these charges against me, saying, well, that I assaulted these people and they don't know if I'm going to if I'm going to be convicted or not and end up going to jail, right? So the attorney, Thea Zumwalt, filed two different cases, right? So she kept piling on charges. That's also prosecutorial misconduct, because one judge looked at things and said, well, that was Judge Rachel McGuckian. This was around October October 26, October 26, 2023. The attorney I had at the time said, well, look, he needs a bill of particulars because he's reviewed the evidence and it's not apparent that I committed any second degree assault. That, in fact, the only assault that he sees is the one that was committed on me. I'm the victim of police assault, right? But miraculously, he said, about almost 40 cops showed up and I didn't touch a single one of them. I didn't assault a single one of them. And he wants to know what type of assault it is that they're saying I committed and on whom, because there's so that they should bring a bill of particulars. So on October 31st, 2023, the Zomwalt comes back. Instead of, answering the question, right, abiding, following the order of Judge Rachel McGuckian, she then files a new case, brings on six new charges, right? Six new charges saying, well, it's okay, it's not one person that I committed this assault on, it's three people. And I did all these lots of stuff, blah, blah, blah. So, and, you know, again, trying to, so that's called piling on charges, right? So that's no trouble. Um, I'm still entitled to defend myself. So eventually, ultimately, after the judge, right, he abused the process. That's Judge James Bonifant. He was abusing the process, using these false incompetency to stand trial orders, to just try and engage in witness tampering, right, and coerce me to still accept some kind of plea bargain offer. Eventually, I'm released. Um, Then I finally get a new attorney again. She registered her appearance sometime July 1st, 2025, and July 2nd, right, 2025, right, at the beginning of July. So the judge then schedules trial to be, he had a hearing status maybe sometime September 4th, 2025. And then he schedules a motion for September 25, 2025, schedules trial for uh, tentatively, as he put it, uh, for uh, for March 2026. March, no, not March, sorry, February, the beginning of February. Schedule it for February 9th, 2026, tentatively, right? But he wanted us to settle, right? To settle out of court. So there was now a new prosecutor who hadn't looked, would come to court. He didn't know what the case was. He admitted, right? New prosecutor named John David Lallis. So um, I'm appearing in court. My new attorney never showed up. She didn't show up on, she had made her appearance when I appeared September 4th, 2025. She didn't show up. Somebody filled in for her. Twice somebody would fill in for her. She would never show up. I'd call, she never responded. So I'd been calling because, I'd been working on this case myself since all the time I was under house arrest. I used the time to investigate the case myself. Of course, I can't go to the scene of the crime, that which was my apartment. Right, the police came to my apartment without an arrest warrant. So, um, so I have to rely on my public defender all the while from the beginning. My public defender, they said, well, she was sending out their investigators to go and investigate the crime scene, get the CCTV, interview witnesses, what happened, right? Fortunately, the states, I guess the state didn't realize that there are people that I have friends in the building where I lived. I lived there for 2 years, right? And that neighborhood, I lived there in for an aggregate of, 6, 7 years, right? So there was someone who, in fact, I had neighbors on my floor that I talked to. One of them had, a couple of them had recorded the incident, what happened. And they couldn't believe I was the one whom the police force, they called it a military force. That there was a military force that came, right? They were wearing military gear. That was what he said. And they told them they evacuated to the building, told them to stay inside. They had some, they didn't let them go back in and all that. But that they told them a criminal had escaped and was holding a woman hostage, right? I'm not a criminal. I've never held any woman hostage. I was alone in my apartment. So they spread this information. So my neighbors recorded what happened, right? So I'd asked my neighbor to appear as witness. In fact, witnesses talked with the state attorney because criminal charges were filed against Jide Iwari and Grandma Shumi. And so there are people who talked with the state attorney and said, well, this is what happened. They filed criminal charges against them. And they, because before they file those charges, the state attorney, is going to talk to them and all that. So for my own defense, right? So typically the case should have been dismissed, but John McCarthy his office has clearly been bribed, because I've done videos explaining how this is actually stemming. It was originally instigated by officials in the Department of Navy and Department of Defense that I'd reported. So this is like a RICO violation. RICO is Racketeer Influence and Corrupt Organization. That's what the federal government uses to get the mafia. Because back then, if they were bringing a prosecution against a mafia head and they had a witness, the witness would disappear the day before the trial, or something would happen. And that's sort of what happened to me, you know. I had uh, there was a federal investigation going on. As of that day, I was an auditor in the Department of the Navy. I'd filed several things. That's my constitutional right. A week before, an Office of Special Counsel investigator attorney was trying to reach me, right? They were supposed to reach me. I was supposed to be participating in certain things. And so when the police came to get me, assault me, it made me unavailable for these uh, proceedings. So that's a RICO violation, you know. But of course, we have to be able to prove and show that it was a government that instigated Montgomery County Police and the state attorney's office and the Judge James Bonifant, that they're acting in concert with them on behalf of those people because they've been bribed in some fashion, right? So, and in any event, that's not what I'm talking about today. What I want to do is just focus on how my public defender from Montgomery County has been sabotaging my case, right? And how these, in all likelihood, sabotage other black people, other minorities, other indigents, right, for the state attorney, and obtain wrongful convictions against black defendants and all other minorities in Montgomery County, Maryland. So they schedule trial for February 9, 2026. Motions hearing was initially scheduled for September 25, 2026. They postponed it to December 12, 2025. Sorry, it was scheduled for September 25, 2025. It was postponed by Judge Bonifant to December 12, 2025. This has been the pattern of Judge Bonifant. He was the chief circuit administrative judge. That's like the chief judge. He manages the schedule. So he's handled this case for 3 years. Been scheduling. His thing is to schedule, postpone, order competency evaluations, find you incompetent, do false incompetency orders, just delaying the process, because so that's using procedural unfairness, abuse of the legal process to help the state attorney obtain a plea bargain offer, and to frustrate the defendant, or to help the state destroy evidence, because evidence is destroyed, it's lost over time, right? The ideal is to get cases to trial quickly, because part of evidence, for instance, witness testimony. Witnesses might, they might move away, they might, they can even become deceased, right? Or they might forget, they might fall sick, right? So the longer it is, they're degrading uh, the the strength of the witness, right? The strength of the evidence that the defendant can use. Now, on the other hand, the state is using false evidence. They can fabricate as much evidence as they want, because, for instance, the charges against me was based on fabricated evidence. Um, the police, they committed perjury. They lied about what happened, right? But in court, I get a chance to be able to show that, well, the police lied, right, by providing evidence. So, um, something the my attorney has not filed a my public defender never filed a motion to dismiss based on speedy trial, because although they had told me a long time ago that they were going to do that, but they hadn't filed one. Eventually, I spoke with my public defender. I looked at her background, her profile. She graduated from Georgetown, the latest one that came for July, right, 2025, because the previous ones I had were no good, right? It was just no good. It was bizarre. But this person, I looked at the background. She'd worked in big law, Baker McKenzie, graduated from Georgetown Law. I thought, okay, well, at least this one's good. She's probably doing it because she has a passion for it. She'll do her job well. And when we first talked, everything seems to be going well. She told me how the police had no arrest warrant, right? So that's a no-no. That's a Fourth Amendment violation. So when there's no arrest warrant, right? It's reason to say, well, the evidence that was collected, that it would be inadmissible, right, to suppress evidence because they had no arrest warrant, they had no right to be at my place, right? So she indicated this at some point. My family went to court in Nigeria to challenge the emergency evaluation petition to show that it was a fabrication. I never received notice. I've done videos talking about that. So, but we had been able to prove, my from family had been able to get a court order from Nigeria. My mother's given testimony, sworn affidavits that one, Jide Wire is not my uncle because he's the one who lied, fabricated information. And then two, everything he wrote was a fabrication because it's a court order. The court has to respect it, right? So the court had been ignoring my words because Judge Bonifant had been violating my rights, my constitutional rights. He wouldn't let me talk. At some point when he let me talk, he heard what I was saying, but he would, dismiss it, because on his delusional, right, on his delusion and fraud on the court, saying, well, that this person must be delusional. That he can't believe anything that I say, right? Even though other people had written petitions to him, he argued, and including my aunt, who's a psychiatrist in Maryland, but he would say no, that they're just doing it to help me, right? And they went, proper information. So, but he believed the false allegations of a man who he claimed was my uncle, but is not. But he didn't, he believed that person. So he was just doing a pick and choose, right? Very selective, biased way he was using evidence, right? So he believes the the perjury of this guy, this delusional guy, Jide Wari, who has we don't share a last name. I wasn't living in his home, but he won't believe somebody who says she's my aunt, she's a psychiatrist, and saying, wait, look, this is what happened. These are fabrications against me. But regardless, I'm still entitled to my day in court. So um, something interesting happened, right? So I'd been waiting. I provided this new public defender all the list of witnesses, right, to subpoena people. So because when you go to trial and you want to present evidence, you want to part of your evidence, part of the evidence you're presenting to the jury, you just don't go in and tell the jury that you didn't commit the crime. The jury has to have evidence of what, to be able to arrive at their decision whether you're guilty or not guilty. So you bring evidence, to court. Amongst the forms of evidence you use will be witness testimony, people, uh, you know, testifying regarding your character, people who were there, who observed what happened. I'd given her a witness list, and we can challenge the narrative, right? Provide an alternate uh, um, narrative of what actually happened, because the police has given their narrative, right, of what happened, and it's false. So if I'm saying that what they're saying is false, we have to bring evidence, right? A testimony, bring evidence corroborating our narrative, right? The narrative we're saying, the jury is more likely to believe the defendant, right, uh, against the state if the jury is able to present evidence. And part of the evidence would be, witnesses, right, witness testimony. So you have to subpoena the witnesses. That means the state uh, compels them to appear in court. They have to appear in court on my behalf. Because if I'm just telling them by word, okay, can you come and talk on my behalf in court, come and say what happened, they might not show up, they might not get involved. But the process of the law is for the state to subpoena the witnesses. I find 7 days before trial, my public defender had not subpoenaed any witnesses, right? She hadn't done any additional investigation, right, on the crime scene. She had done nothing. So she just wanted us to walk into court, right? Walk into court and just say, no, he didn't do it. She had already, so she had come to me and said, hey, that she doesn't see any evidence of what the police is saying, right? And she's assuring me that no, I can't get a conviction. I can't get convicted because one, the police didn't make the statutory arrest. That if they accuse the sort of assault they're accusing me of, if it's intent to frighten, there's statutory elements to that intent to frighten. Uh, and she's saying, well, the police, they can't satisfy those statutory elements, right? A part of the elements include, I've done videos regarding this. That's there's got to be the frightening, right? The threatening act, right? Whether it's raising a fist or charging the police with a weapon, a threatening act. So intent to frighten, there's no offensive touching, right? But they create some kind of fear, right? That they're going to be there's imminent harm. Then there's criminal intent. There's intent to frighten them. It has to be there, right? Intent to harm them, intent to frighten them that they're going to, right, cause them bodily injury, right? That's one, two, and third. There's the third element that the police did have a fear, a reasonable apprehension, right, of being of suffering imminent bodily injury. So those elements have to be there. So she said, no, those elements are not there, right? There's no intent. I was backing them. I had no intent to hit anybody that hit the police. There are 40 cops pointing guns. That's not going to work. And I had no, I was being swatted. I knew I was being swatted. She knew that. So she said, look, we're just going to walk in on that day and say, well, they don't meet the statutory element, so therefore acquit this man. Acquit him, and he's not guilty. But Montgomery County's public defenders had been committing so much deception, perpetrating so much deception, right, and so much fraud that I couldn't. I was entitled to better, right? I saw this person wasn't prepared. There was no witness on my behalf that she'd subpoenaed. She'd gotten no evidence on my behalf. Meanwhile, there was this false testimony by the police against me. During the motions hearing, she had the opportunity to file a motion to dismiss. She said she went to meet the state attorney to dismiss the case, but he refused. And so she said, well, we're going to go to trial. No. So she said, well, so when she said they refused, I said, then why don't you file a motion? She said, she thought she could deceive me. She said, oh, there's no motion to dismiss for insufficient evidence. There's a motion to dismiss for vindictive prosecution, right? That's what happened with Letitia James, with the former FBI director Comey, right? You can file a motion to dismiss based on vindictive prosecution. And look, they didn't meet the requirements to file these charges, right? And they're filing these charges in order to in order to protect the police, so there's no prosecution against them for misconduct, right? And it's also to obstruct justice. One would provide those reasons. So she failed to do her job. In any event, this video has gotten long. I'm going to continue it in a subsequent video on how Montgomery County's public defenders sabotage the cases of Black defendants, indigent defendants, and get them imprisoned, get them either imprisoned or coerce them. They're co-opted by the state attorney's office and, crooked judges like Judge James Bonifant to sabotage and co-opt them to take wrongful plea bargain offers. My name is Olurotimi Osha. I'll keep you posted. Thank you.